New documents were filed today in the case of Justin Baldoni versus Blake Lively. Justin requested and was granted a summons for the New York Times. They had already been named in the case but had not been served yet. In addition, an official order was filed as a follow-up to the pre-trial hearing that was held on February the 3rd. Several new attorneys have been appointed, and we have a scheduling order. And that's what we're going to mainly discuss today. Legal documents are carefully crafted by attorneys after days or even weeks of research. They're often looked at as boring, monotonous, or even confusing with their specialized legal terms. But inside each one is a story built on a client and the history of similar cases to support that client's story. I can get lost in these stories, reading every citation, analyzing the attorney's point of view, meditating on every word to try to reconstruct what happened, find the truth, and above all, watch as hopefully justice is served. I'm Cassidy O'Connell. If you're looking for all of the details of the story and not just salacious tidbits, then you've found a home here. This is the other 55%. Because we don't know the half of it. Justin Baldoni versus Blake Lively. The scheduling order has been filed. What does that mean? Welcome. Scheduling orders are an outline of the important dates and deadlines, and they're issued by the court with input from counsel. They serve to keep the trial moving along smoothly and on time. They follow timetables that are allowed for each of these items to be completed. Some of them do have allowances for requests for more time, but between the order regarding the pre-trial hearing and the scheduling order, we now have 14 deadlines set up. And that's what we're going to walk through today. If you've followed me for a while, you've been through this walk with me before, as we trace the steps leading up to a trial. From where we're at now with the complaints having been filed, we're going to move on to discovery and witness the building blocks of putting a trial together. The whole basis of this really is called discovery. Discovery is basically evidence. It can be many things, from documents, in this case we'll see videos. It can be emails, text messages. It's also things like witness lists and the information that those witnesses intend to bring. Basically, any evidence that both sides intend to use. Every state has their own rules to govern discovery, but since this is a federal trial, it must adhere to the federal rules. These rules are put in place for fairness. There isn't supposed to be any kind of trial by ambush. Both sides are supposed to share discovery so that the opposing side can prepare effectively and avoid unnecessary court delays. This also gives them a chance to object to and strike discovery that doesn't follow the rules, or that may be deemed privileged by the court. We just covered this process in the Nautilus trial that was held last month. We come to our first deadline, which is February 18th, so coming right up, and it is the initial disclosures. As I mentioned, these deadlines have been set up by rules, so we're going to take a quick peek at those rules to help us understand this process. The federal rules about initial disclosures, this first deadline, are found in Rule 26, specifically A1. First on the list would be our witnesses. So each side has to provide to the court and to opposing counsel their witness lists. That would include the name, the contact information, and what that individual knows about the case, including specific subject matter. So any witnesses that are brought to the case are opened up to the other side as well. They don't just get to come and testify on behalf of whichever side they're called for. Their information and what they know must be disclosed in this very initial part of the process. Second would be documents and other things that will be used. And at this point, this would be copies or descriptions. So they're not delivering all of these items to the other side at this point. This is initial disclosures. So this would be a brief description of the document or the item and the category they would fall under. So is it a contract? Is it an email? Is it a photograph? Is it a video? What is it? and also where this document or item is stored. Third would be a calculation of any type of damages. So were there medical expenses incurred? Were there wages that were lost? So not only the amount, but a breakdown of how this amount was calculated, any data that was used, or relevant documents. And then fourth, if there was any insurance agreements that would help cover some of this. This is the first building block. So from here, each side will have an idea of what the evidence will be, who the witnesses will be, and then they each start building their cases. So they will gather information based on each other's disclosures. If they see a certain witness and what that witness's knowledge of the case is, they want to get familiar with that witness and what their testimony might be, so that they can prepare things like cross-examinations, or they can look for ways to defend themselves against that witness testimony, counter-witnesses, things that will disprove what this witness might say. Next on the list, we have a March 11th deadline for the Joint Proposed Protective Order. Not all discovery that's brought to the court will be allowed to be used for the trial. So say a witness is going to testify, there could still be limits placed of what you can ask of that witness. That witness should be protected from undue burdens, from oppression, from embarrassment. Maybe something occurred at a certain time and place that it's not necessary to know where that was, and that could be embarrassing. That could be limited. Certain subjects could be outside of the scope of disclosure. Of course, things like health. It can be little things like who may be present while discovery is conducted. Then you can get to privileged items like trade secrets, research and development that's confidential, things like that. Now, both sides are supposed to come together and agree on this proposal, but this is an area that can quickly and easily become contentious. Each side is looking out for themselves. They want to block discovery from the other side, and they want their side's discovery allowed. So what's put in place to help this is that if they can't come to a joint proposal, each side can file their own version, and this would require a hearing so that each side gets a chance to plead their case of why theirs should be protected or why the others should not be protected. Now we have a specific problem in this case that's not in every case. Two of the defendants are married to each other, Blake and Ryan. As such, there is something called spousal privilege, where they do not have to testify against each other. They don't have to disclose private conversations. And then, of course, we know the other cases, clients and lawyers, patients and doctors, or clergy and the members of their congregations. There are also other private matters, like a person's sexuality, their spiritual or religious beliefs, or information about family relationships. And in Blake's original complaint, not the lawsuit, she does mention Justin's religious beliefs. So this would be probably one of the things that would be excluded. Personally, I see this part of discovery becoming very contentious indeed in this case, because we've already seen Blake's team try to place a gag order over the entire case, which was quite hypocritical because this case began with an article released in the New York Times. She also tried to get out of being deposed by Justin's attorney. So obviously there are things that they're going to try very hard to get hidden or suppressed. Our next deadline is March the 14th, and this is for initial requests for production of documents. So this is the second building block. The parties have made initial disclosures, which are like lists, brief outlines, brief descriptions of what they have, and the witness lists. Now, they can request production of copies of discovery from each other. So after they get a look at the witness list and the evidence descriptions, they choose where they want to start, and so they can request production of copies of the discovery that they want to look at more specifically. In some cases, there may not be a whole lot of discovery to choose from. In other cases, there will be boxes and boxes and boxes. So you start with what looks the most important and request those to be produced. And these requests are viewed very importantly by the court, so that if these requests are not fulfilled within this allotted time, the court can issue a subpoena to demand that these be brought forth or be held in contempt. Also on March 14th, we have interrogatories. Each side puts forth a list of questions to the other side, but the answers are very limited, very brief, and extremely careful so as to avoid implicating their clients. Sometimes the answers are too vague, and the other side can ask the court to step in by filing what's called a motion to compel. And again, if the party doesn't comply, they risk being held in contempt. April 18th is the deadline for filing a motion to amend or to join additional parties. This one's pretty self-explanatory. It may happen that in the course of inspecting these initial disclosures, or in the answers to interrogatories, it may come up that someone else needs to be joined to this lawsuit, or that the lawsuit may need to be amended. And so that deadline is April 18th. The next deadline is a few months after that, July the 1st. This deadline is for substantial completion of document production. This is a key deadline in cases because of the importance of each party not being allowed to withhold their discovery. Now, substantial completion doesn't mean all, but it should be the bulk of the documents, because what can happen, all along there's supposed to be a rolling production of discovery. That means as each side builds their case, they provide it to the other side. But sometimes this rolling production becomes a trickle, just putting out little tiny bits, and then saving the bulk of the documents just before the deadline. And this goes against what the rules are in place for, because that leaves the other side to scramble to try to review everything and not really having a fair amount of time to prepare their side. So this deadline keeps each side from holding off too long in the discovery process. So at this point, a good substantial portion of the discovery must be shared. About 6 weeks later, on August 14th, we have fact discovery completed. And this is just what it sounds like. The process should be completed at this point. And this is where they supply things like their more complete list of witnesses, more complete list of documents, videos, things like that. Now also this same deadline, August 14th, they can now begin taking depositions. Remember the pretrial hearing they just had, the topic of depositions came up, with Blake wanting to refuse to be deposed by Justin's attorney. The judge basically said, it's way too early for this, I'm not ruling on this right now, because there wasn't a complete list of witnesses or these other things that we've already seen, and honestly it would have been silly for them to depose her right now, without having these disclosures, without these documents being produced, and also without having decided what was going to be protected information. Some people were making a big deal about the fact that he didn't force her to be deposed, but it's not surprising at all. It simply wasn't time to deal with that. None of these initial steps had taken place yet. So in this step of the building block, this is a very important one. At this point, they will have their lists of witnesses, opposing counsel's list of witnesses. Now they want to find out exactly what these witnesses have to say. Depositions are very serious. They're really an extension of the court. They're taken under sworn oaths. They're attended by a court reporter who produces transcripts for trial purposes. They're also recorded, audio and video. And these are key pieces of evidence in trials. What's more, and probably the reason Blake really is afraid of being deposed, is that counsel is very limited during a deposition to stop questions from being asked or answered. The most they can really do is object to the form of a question. But that's about it. The person being deposed has to answer the questions they're asked, and they're under oath. So since you're under oath, you can face perjury charges and even jail time for lying during a deposition. During a deposition, evidence can be brought up and used against you to contradict any claims that you make during this deposition. So, for example, the single piece of evidence that got me so involved in this case was that the accusations that Blake made in her complaint, the complaint that predated the lawsuit, were certain things that Justin supposedly said to her at a specific time. I've shown clips of this video, but it was that video that was made while they were dancing together. The bulk of her claims against Justin for improper conduct were in this little clip. She made some claims about it. She claimed it wasn't filming for the movie. She made claims about what he said to her during this video and what was happening during this video. She also had stated that there was no audio for this clip. And I think that's what made her feel safe to misrepresent what happened there. Fortunately for Justin, he was wearing a microphone, and he probably did so for his own protection. After these accusations were made public, Justin's lawyer put this video out to contradict her statements. So, for example, had she made those statements that she made in her complaint during a deposition, opposing counsel could have pulled this video out and played it as proof that she was lying. She's actually fortunate that this video has already been released because it gives her a heads up. Now she knows not to put this in the official lawsuit. And it also will make her think twice about any other allegations she might make, not knowing whether or not Justin was mic'd during the time. Even though from the perspective of the lawsuit, it might not have been the best move to release this video when they released it, because it could have been there to contradict her testimony, I think for Justin, and this is just my thinking, it's not anything that he has said, but it's what I would want to do. For the sake of his reputation, he was being called a sexual predator by Ryan Reynolds. He was let go by a talent agency. This was bad for him. So I think for the sake of his reputation, and also, Justin's married. He has a sweet, beautiful wife. From all appearances, they're a very close-knit family and couple. This is another reason that I got so invested in this case. Because these accusations, they don't just harm Justin, they harm his wife. And that's why I think for her peace of mind, he wanted to put this out, to show not just her, but the world, that he was not betraying his wife, that his kisses and his hands on her were part of filming a montage for the movie. It was not being done off camera, which would have been inappropriate. I get so angry on behalf of his wife for not only the rage she must feel for all of this, but the humiliation. Imagine being so public and people thinking that your husband was inappropriately putting his hands on another woman. So even if it did give Blake and Ryan a heads up to stop them from impeaching themselves on this particular point and to think twice about impeaching themselves because there might be more video like this to prove them wrong, I think for him as a person, this was necessary. For him, for his relationship with his wife, for his family, and for his reputation. And it really did create a shift in public opinion about Blake. August 14th is a deadline for requests to admit. This is also something that it sounds like. It's similar to interrogatories, but more narrowed down. This is a request for the opposing side to admit to certain facts or documents being true or authentic. This saves time because once they are admitted to, these are facts and things that don't have to be proven at trial. So most of these rules are all about speeding up the time that needs to be spent in the courtroom. So that once you get these facts that are agreed upon, it leaves time to focus on things that are not agreed upon. And if the key facts are admitted to, it can lead to something called summary judgment, which we'll get to in a moment. The next deadline is October 15th, and this is for all discovery, and expert discovery is listed separately. So this is the next step in the building block. So the cases were built based on each other's disclosures. Based on the witness information, depositions have been held. Once they heard these depositions, they could further build their case with things that weren't possible before. We've gone through the initial disclosures, the substantial, and the fact completions. So full discovery is now made available for each side. Now the expert testimony, in this case, experts could be producers, executives from the Producers Guild, directors. It could include the intimacy coordinator. Anyone who can speak on what production of movies looks like. Because most of us, and of course a jury, would have no idea about these things. So they could come and testify to things. For example, so Justin, as the director, had the right to have 15 days of exclusive time to make his director's edit. This is something that's decided upon by the organization, but Blake intervened. There could be experts to speak on her accessing footage at home and not in the studio, her making Justin leave the studio, her lying about that rooftop scene being written. She gave two different stories, and they can't both be true. There's plenty of evidence of her telling Justin that she wrote that scene, and then there's plenty of evidence of her in interviews after the movie saying Ryan wrote that scene. Ryan was not a part of this project. There could be experts to testify on what that means to a company to have something like this happen. Those are just some ideas of what the expert witnesses might be. The next deadline is October 21st, and that is the post-discovery status conference. So once they have all of this complete discovery, the expert testimony, everything, they have a chance to object again, to file motions again, and so this status conference will be a chance for all of that to be heard. In this conference, the next steps are decided. The judge will decide whether or not to go on with the trial or if a settlement should be reached. If it's looking more like a settlement, this would be when that settlement agreement is negotiated. If they're going to go ahead with the trial, there will be more timelines set up for pre-trial matters. And now we'll get to the point I said we would get to. On November 5th is the deadline to file a motion for summary judgment. So if in the process of discovery or during depositions, it becomes glaringly evident how a jury would rule, one side can file this motion, which is asking the judge to rule in favor of their side to skip the trial completely. Or it could be, in a case like this with multiple defendants, if through the course of discovery and depositions it becomes evident that one of them is not truly liable, that defendant can also be removed from the case at this time. These motions are often filed, but not as often granted. And that brings us to the final deadline that we have at this time, and that's January 23rd, 2026. And this is the joint pre-trial order. This essentially lays out all of the issues for trial. It includes the final witness lists, any restrictions on those witnesses, the evidence list, deposition testimony that's going to be used at trial, stipulations of fact, expert testimony, things like jury charges, and we just talked about what those were and how those are come up with in the Nautilus case. But it's kind of the kitchen sink, really. Laying out your trial before you begin to try the case. And this is put in place, like all these other rules, to help the trial be able to move along without so many interruptions. This, again, is supposed to be jointly prepared, and just like the previous one, if they can't agree, the judge will make those decisions. But this order is a signed order. It's just as impactful as the judge ruling on things during the actual trial, but it gets as many things out of the way beforehand as possible, and this is done a very short time before the trial begins. It does leave them a little bit of time because decisions will be ruled on here, so there may be bits to their discovery that now has court-ordered rules about it that they have to adapt. But this is the bulk of all of the court's decisions and rulings, and there may be some tiny little things that have to be cleaned up right at the very end. That's the last deadline that we have for now, and so that brings us up to speed with what has been filed up to today. In the meantime, I've also been preparing Part 3, a review of Justin's complaint, but I wanted to take this moment because this is kind of breaking news and I wanted to get this out to you. I had a bit of a tight schedule the last few days, but hopefully Part 3 will be coming very soon now that I've got a little more time. Till then, this is Cassidy O'Connell saying stay well and stay tuned.